Hello, my name is Kirk Livingood, and I'm a Senior Risk Consultant with Applied Risk Solutions. Today I'm here to talk to you about accident reporting and investigation and what you as a supervisor must do anytime somebody reports an accident or an injury so that you don't give up legal rights under the workman's compensation system. Failure to do these things can have significant impacts on the cost of managing claims and significantly increase your liability so that you end up paying claims that you otherwise could have denied. First step in managing this process is to understand what should be reported and when you should report something. I want you to watch this following video and tell me what you think.
Hey Bob, how's it going?
Hey Billy, I'm good. How you doing?
Good, man. Just letting you know I was just outside taking the trash out and had a little spill. Slipped and fell. Not a big deal. Just wanted to let you know about it. Kind of busted my knee up. I'd probably finish the shift or whatever, so it's not a big deal. Probably don't need to go to the doctor or nothing. So.
Okay. Sure you're gonna be all right?
Yeah, I'll be all right. No worries.
All right. Well, let me know if you need anything.
All right, we'll do it. Appreciate you.
Well, what did you think? Yes, this definitely should be reported and documented, and there are certain things that should take place immediately following these kinds of reports of injury. At the exact moment somebody tells you that they've been injured, if you don't take certain actions, you're going to give up legal rights as an employer, which you do not want to do. The first thing you have to do is you have to fill out an accident report, and you have to get the employee to fill out an accident report. You have to fill out a medical authorization form. You need to get witness statements, and you need to direct care depending on the laws in your state. I'll talk about that more later. You need to get them to sign a form if they don't want to go to the doctor, denying medical treatment. And at that time, if you are in a state that directs care or it's a panel state, you're going to need to be sure that they know where they should go to the doctor should they change their mind at a later date and need to go. You need to send them for a drug screen, and you also need to send the reports to Applied Risk Solutions as soon as possible. As soon as someone reports an accident or an injury, you really only have about 8 hours after that point to get a drug screen. Regardless of whether or not they want to go to the doctor or not, if you don't send them for a drug screen after the first report of injury, you're going to give up that right as an employer. It's not uncommon for somebody to have an accident injury, not want to go to the doctor, maybe you get them to fill out the stuff, and then a week or even days later they decide, you know what, I'm still hurting, I need to go to the doctor. If you get a drug screen at that point, it's too far removed from the time of the first report of injury, and you're not going to be able to deny coverage under workman's compensation laws under the drug-free workplace. The following is a picture of our form for the medical authorization form. This form serves two purposes. The first purpose is so that Applied Risk Solutions can get the bills from the facility and pay the bills. The second reason for this form is so that it authorizes Applied Risk Solutions to get a drug screen results from the individual. If you're sending them to two different locations, because ERs oftentimes will not do a drug screen, you'll need to fill out two forms, one for wherever they're going to take their drug screen, and the second one for the treating facility. One of the primary employer rights under workman's compensation is the ability to direct care and pick the doctor. Not all states have this, but most have some form of it. I'm going to go over with you in a few minutes all the different laws in general for the states so that you'll know what state, what the laws are in your particular state. But bottom line, if it is a right of an employer in the state where you reside to decide where the treatment is going to take place and what doctors that the employee can see, this is a very critical right you do not want to give up. The last thing you want is for an injured employee to be seeing his attorney's favorite physician. If that happens, I can assure you he's not going to get released from work. They're going to run medical bills through the roof, and your workman's compensation insurance carrier is going to have no choice but to settle this to get out of the high medical costs for the claim, okay? The following states are panel states. A panel state is a state that requires the employer to post a list with a specific number of doctors and sometimes different kinds of practices. And employees must choose a doctor from this list if they want to seek medical treatment for a work-related injury.
Well, we've got a panel list of physicians where you need to go if you need to seek treatment.
What's that?
It's right here, man. If you'll let me know,
I've never
if you
seen
need to
that
seek medical
before. I
attention,
don't-
then
Shoot, you don't
can
let
pick a
people
place
come
from the
hang out
list.
here. I didn't know. Oh well, I guess I should have asked you about it first. My bad.
If you don't post a panel, or it's posted in a non-conspicuous location, or if there are doctors on the panel that are no longer accepting workman's compensation insurance or no longer practicing, or it's not a legal panel because the right number of physicians and types of physicians have not been posted on the panel, it's an illegal panel. And if an illegal panel is posted, the employee can choose to go to anybody he wishes to see. It's critical, if you are in one of these panel states, that you have a legal panel posted and your employees acknowledge in writing that they know where this panel is and that it is the only list of doctors that they may choose regarding a workplace injury. If you'll notice on our panels, ERs are not listed. The reason for this is ERs are only for life-threatening injuries. We strongly recommend keeping employees out of the ER unless they have a life-threatening injury. Getting them to an urgent care or to a regular orthopedic or something like that is not only going to save you significant amounts on your medical bills, but it's also going to provide the ability to have follow-up treatment and have a physician that can treat into the end of the illness or injury. The following states are employer-directed states. If you live in one of these states, Applied Risk will supply you a panel, but you're not required to post it. In these particular states, the employer decides where the employee is going to go. The employee doesn't get to pick from a list. The employer decides. So if you're in one of these states, you send them to an urgent care or to an orthopedic off the panel that we've given you and ensure that the employee knows that that's where they're supposed to go. These other states are employee-directed states. Unfortunately, if you're in one of these states, the employee can choose to go wherever they want. It's not good for you, but it's the law. I strongly recommend that if you're in one of these states, that you maybe try to persuade them, hint that if I were you, I would probably go down to the urgent care because you're going to find a good doctor there that you can go back and see later. You'll be able to have follow-up treatments. You're not going to have to sit in the ER for 4 hours, 5 hours, 6 hours, or however long until you're the next most critical person, because most people in the ER have life-threatening illnesses, heart attacks, strokes, bad car accidents where their life's in danger. And I usually remind people that the whole time that you're sitting down at the doctor and doing that, that's unpaid time. So you're going to leave work, you're going to go to the doctor, you're off the clock. So just encourage them to go to an urgent care or something like that. If they want to go somewhere else, it's 100% up to them. You can't tell them not to. But again, giving them good advice is okay. The following states are states where the employer picks first and then the employee gets a chance to change at a later date. Each of these states, the laws are a little different, but bottom line, you get to pick where they go to start, and you should exercise that right. The states are different in that in some states it's after a certain period of time, and in other states the employee may have to appeal for a change, but bottom line, these states, you pick first. This next list of states are unusual rule states. For example, in New Mexico, either the employer can pick first or the employee can pick first, but whoever picks first, it can be changed by the other person at a later date. So if the employee picks first, the employer has the option to change at a later date, and then the medical stays that way for the lifetime of the claim. If you're in New Mexico, I strongly recommend that you let the employee decide where they want to go if they injure themselves. That way, if this thing drags on a long time, you have an opportunity at some point to change the doctor to the doctor of your choice for the lifetime of the claim. All these states are different, so all I'll tell you is if you have questions about any of these states, you need to get in contact with Applied Risk Solutions, and we'll go through the details on each of these other states individually. Now I want you to watch this next video just so that you can see what happens, and often does happen, when someone reports an accident or an injury and you don't take control of the medical.
Billy, how you doing?
Hey Bob, what's going on? So the other day, I told you I slipped and fell.
Yeah.
Well, I busted my knee up, and it turns out I went home and I couldn't sleep. It was hurting me real bad.
Well, that's not good.
So I ended up going to the ER and getting that taken care of. And they told me they ran some tests or whatnot, X-ray, blah blah blah, and gave me told me to go to a specialist or something. So I went to them this morning, and there's the bill from the ER, like $4,200 or something.
$4,200.
And then
So what all did they do for you at the ER?
I don't know. They just X-ray and looked at it. Then they told me to go to some knee specialist. I don't know.
Well, I thought you were doing all right after we talked last week. You should have let me know you needed to go to the doctor.
Well, I was, but then it started hurting me real good there at night.
$4,200. Well, we've got a panel list of physicians where you need to go if you need to seek treatment.
What's that?
It's right here, man. If you'll let me know.
I've never
you
seen
need to
that
seek medical
before.
attention.
This is a good example of what we see all the time when managers don't take control of the situation. Aside from the fact that Bob now has very large medical bills to deal with, he didn't get a drug screen soon enough, and as a result of the accident, he's given up some rights under the drug-free workplace. Here's what should have happened when Billy first reported that injury.
Billy, what's going on?
Not much, man. Just kind of taking the trash out, slipped, fell, kind of busted my knee a little bit, I think. Yeah.
How'd that happen?
I don't know. Might have slipped over something or hit a curb or just kind of slipped and.
Did anybody see it happen? Or?
I think somebody might have, but I wasn't sure.
All right. Well, hey, I'm glad you brought it to my attention. There is some paperwork that we'll need to go over and that you'll need to fill out here.
Okay.
Just so that it's on record that it was reported to us. Do you think it's something where you need to go to the doctor? Or?
Yeah, I think so, because it is hurting pretty good.
Okay.
I just want to make sure, get it checked out and make sure it's okay.
Okay. All right. Well, I think that's probably a good idea that you go and get it checked out then. We do have a list of panel doctors where you'll need to go for treatment. But just want to go over the forms with you. So first of all, this is just kind of a summary of what happened. You'll need to fill it out with your information at the top.
Okay.
List what happened, your injured body part. Make sure you be specific with what part of your body was injured. So then we'll step over to the panel physician list, and you can select a doctor, and you'll need to list their information here.
Okay.
All right. If there are any witnesses, we'll need to get a statement from them as well. All right. So step one is selecting a list from our panel of doctors here. So we got a couple urgent care clinics on there. Do you see one that'll be convenient for you?
That one right there.
Well, that's a specialist. So step one is to get you into an urgent care facility.
Well, I was just
And
thinking
then
that
they
one
may
was
direct
close.
you from there.
Okay, that one was close to where I live, but so an urgent care is one of these two here.
Yeah, one of your top two options there.
Dorchester isn't too far. I can probably make it there.
Okay. All right. So we'll put their information here on the medical authorization form. And so we're going to need you to go in there and have a post-accident drug test done. This is a drug-free workplace, so we just need to make sure that you're in compliance there. This also authorizes them to do the initial examination and treatment for your knee.
Okay.
So you can take that with you when you head into the clinic there. The second form here that you'll need to take with you to the clinic is a modified duty work release.
Okay.
So we do offer light duty to you. We can accommodate if they say, hey, there's some certain restrictions pertaining to how much weight you can lift, anything like that. Just make sure that you let the doctor know that we can accommodate your restrictions and that they need to give you a list of what those restrictions are. So you can have them fill this out and bring this back into me after your doctor visit.
Okay.
So you can take that with you and head on out to the urgent care facility and let them check you out. Hopefully we get some good news. It's nothing serious, and we'll see you back at work. But if you have any issues, if you're not able to return, if they do some workups and any significant injuries. Make sure that you keep in touch and you let me know. All right.
We'll do, Bob.
So, and one more thing. So, we will go ahead and put our risk management firm, Applied Risk Solutions, on notice of your incident, and they will try and reach out to you in the next 24, 48 hours. So just be expecting a call from them as well. And they'll just want to go over a lot of the same things that we discussed here today.
Yeah, I'll keep my phone handy.
All right.
Yes, I can talk.
All right, Billy.
See
Good
ya.
luck.
Accident investigation is very important. It's several components. You have the accident report that the supervisor fills out. You have the accident report that the employee fills out. And then you have witness statements. Several reasons you want to get a good accident investigation, because often when you do a good investigation, you get down to the actual root cause. What was the employee doing? Why did this happen? We don't want to just know that he fell down or slipped or somebody cut themselves. We got to get down to the root cause of what they were doing. Now, for this reason, the supervisor is going to fill out his report, but it's very important that the employee fill out in their own handwriting exactly what happened. The reason we don't want the supervisor just taking the statement and filling out what happened or filling out the employee's form is that people who are dishonest, their stories change. And often the excuse we hear when the supervisor fills out a report for an employee and the employee signs it is that, well, that's not what I said. That's what he wrote down. I couldn't read his writing, but I absolutely didn't make that statement. If they put it in their handwriting and they sign it, they have a very difficult time refuting that that's what they say happened. So we want to get it down to where their stories can't change. They've said exactly what they've said, and they can't take it back. The second thing we want to be sure happens is that we want to be sure that the accident report reflects the root cause of the injury, because not every accident that happens at work is considered a compensable accident under workman's compensation. There are many circumstances to where somebody can be injured, become ill at work, and the employer is absolutely not responsible under law for having to pay for this. There are a lot of examples of things that would be considered out of course and scope for employment. Anytime somebody decides to do something of a personal nature, or they're goofing off or playing or something like that, and management is completely and totally unaware of it, that becomes an accident that is not compensable under workman's compensation insurance. Examples of this would be two people goofing off and playing, management's unaware of it, and somebody's injured.
Oh my God, are you okay?
It hurts so
Yeah,
bad.
what's going on? What happened?
He was trying to kick that ball and he hurt himself.
Yeah.
Is he all right?
I don't think so.
Oh my God, I'm
Did you
worried.
call an ambulance?
Yes.
Yeah, I think so.
Think you can get up?
Yeah.
Come on.
A little bit of
Come
help.
on. Oh,
Let's take you inside.
you got
Shanna, if you
balls.
want to.
Another one might be somebody decides to deviate from their job and run a personal errand. Could be that somebody was driving from one point to another, it was work related, and then all of a sudden they decided to run by their house and unlock the door for their child, or go inside and fix lunch, and their employer had no knowledge of this. And in the process of making that drive to their house or leaving their house, going to the gas station or the bank or some personal activity, they're involved in an accident, crash, or injury, that would not be compensable under workman's compensation because it was not work-related. They deviated from their course and scope of employment. Other examples might be at break time, maybe a couple employees decide to go out back and play soccer. And during lunch, they're out back playing soccer, and one of them falls down and breaks their collarbone. Now, here's where it gets a little tricky, because if management was completely unaware and had not given authorization for these activities to take place, that would be considered horseplay and would not be covered under workman's compensation. However, if the supervisor was aware they were out back playing and did not stop them, okay, it now becomes potentially compensable under workman's compensation insurance. It's very, very important to make sure that your supervisors are aware that they should never allow employees to do any activity outside of their work during work. If they want to do something like that, they have to clock out. And my recommendation is to get them off property if they're going to do something like that, because even if they fall down on your property, there's still an opportunity for a general liability claim. Another example would be personal work. If somebody was welding in the shop, for example, and they kind of snuck a part in from their lawnmower and they were fixing that and they ended up injuring themselves. And again, management or nobody in supervision had authorized them to be conducting and doing this personal work. Again, that's out of course and scope, would not be covered under workman's compensation. Another group of injuries that are not covered under workman's compensation are idiopathic injuries. These are injuries that occur because there was something already wrong with the person. It just so happened it happened at work. It could have happened at home, it could have happened while they were shopping, but they just happened to be at work when this injury occurred. The key point here is there was not really an accident that caused this injury to happen. This could be somebody just standing up to walk from one place to another, and all of a sudden their knee gives out on them. They didn't slip, they didn't fall, they didn't trip. They obviously had something wrong with their knee. A heart attack is another example of an idiopathic injury. Unless, as an employer, you had the person outside in 100-degree heat running them up and down the hill, and the person had a heart attack because they were overstressed or something like that. But generally speaking, somebody who has a heart attack is considered an idiopathic type injury. Watch the following role play so you have an idea of what this is like when somebody reports an injury and it's idiopathic.
Hey Shanna, can you come give me a hand with this case file?
Yeah, hold on, John. Give me just a second. Let me click out of this one real quick. Oh my God, John, did you just hear that?
Are you okay?
No,
What
my
happened?
knee popped. Oh my God, I think I need to sit down. It acts up like this sometimes. Oh my gosh. Hold on, I'm gonna have to help you in a minute, John.
This is why it's important for the employee to write down and you get to the root cause of the accident. They say that their knee popped. Why did your knee pop? Did you slip? Did you fall? Did you trip on something? Get them to write it in their own handwriting, because it's very critical to have that good investigation done so that these claims can be denied. Another reason a good investigation is important is because, again, not all injuries that occur while somebody's at work is the responsibility of the employer. Many injuries are caused by third parties, and while workman's compensation is going to cover your employee, your workman's compensation carrier will sue to subrogate recoveries if third parties are found to be negligent. If you have an employee working on a job site somewhere and it's an unsafe condition caused by the GC, or maybe they go to do some work at somebody's house and the steps are broken, they're walking up the step is rotten, they fall through the step, they fall down. Maybe a dog comes out of the door and jumps on them and they fall down the steps or bites them or something like that. You have third-party liability if somebody else caused this injury. And to be quite honest with you, if it is a minor injury, the insurance company is not going to subrogate. You're just going to be stuck with that claim. But often we find that some very significant injuries happen this way. And because the third parties were not put on notice, they weren't notified of the injury on their property or the unsafe condition, we didn't document the steps were rotten or the handrail was missing, we didn't do an investigation, document, gather the evidence together, we lose our ability to subrogate these kinds of claims. We've seen very, very expensive claims where people have fallen down steps that had been iced over for weeks and torn ACLs, 6-digit type claims or worse, to where they're very serious injuries caused by other people's negligence. And because we didn't notify the homeowner or the business owner of the unsafe condition, we didn't document, we didn't take pictures, we give up that right to effectively subrogate these claims. Witness statements. Witness statements are very, very important. You often get a completely and totally different piece of information when you get witnesses to tell you what they saw and what they observed happen. I want you to watch this next role play so that you have an idea of how a witness statement can be very, very important in subrogating a claim against a third party.
I just slipped on that stuff that they had laying out and I hit my head.
Oh my goodness. Well, let me go get Bob real quick and we'll take care of this. Bob!
Please.
Come on up. Come on over here.
Hey guys, what's going on? You alright, Veronica?
No.
The contractor that was out here, there's some oil that he left laying out here, and Veronica slipped on it. And I think she hurt herself pretty good.
I know.
I think I might be bleeding.
You think you can make it into my office?
I'll try, but we need to do something and get this stuff cleaned up.
Okay, yeah, we'll get that taken care of. Billy, you want to help around?
Thanks, guys.
There we go.
The other thing you need to do, if your operation has video cameras, you need to secure the videotape immediately after an injury, and be sure that we can reference that and look at that if we need to verify what's happened. The next thing you need to do as a supervisor, you've already had the employee fill out their version of what happened, is you need to kind of pull all this together in your supervisor's report. You've got your witness statements, you've got what the employee has written down that they said, you've kind of talked and looked at the situation, you've secured the camera, looked at the footage. This is the time for you as an employer, as a supervisor, to fill out your version of what happened and kind of pull it all together if you see anything that is out of the norm or out of the ordinary. Doctor's visits. These are very, very important. If somebody's injured, I strongly recommend that you provide transportation for them to the doctor. Remember, you're going to get a drug screen. There's been an injury. There's reasonable suspicion that they could be impaired just by the nature of the fact you're going to get a drug screen. So you want to be sure that you provide them safe transportation to a medical facility. And the other reason you really want to do that is so that you can be sure that the doctor that you get the medical release for the employees, so either they're released for full duty, or it gives you an opportunity to where if there are restrictions, you can question them. Please be sure to not just allow the doctor to tell the employee that they can't come back to work unless they are literally very, very seriously injured and they're going to be restricted to the bed or something like that. It's not the doctor's responsibility to tell you if this person can return to work, because we recommend that you provide some type of light duty work to keep these people employed. The last thing you want is your injured people to sit home, not have a job to go to. Keep in mind that one of the first things that happens when somebody's injured at work is that the first thing that goes through their mind is, I'm not going to be able to work. I'm not going to get a paycheck next week. How am I going to pay my bills? It's a very, very traumatic, serious thing. In fact, many times people don't report injuries and they try to work through it because they need a paycheck each week. And one of the most important things you can do as an employer if somebody's injured is to quickly assure them that you're going to get them back in there to work on light duty. You're going to take care of them. You'll find something to keep them employed. The other thing is this, if you just let them stay home and they draw workman's compensation, you're going to be paying that. And be quite honest with you, for about every 60 cents an insurance company pays out, they bill you $1. That's pretty much the factors they go on. So if you're paying them, if their insurance company's paying them a certain amount to sit home, they're going to be billing you about 40% more than that, and you're not going to get anything out of them. It's a much better for you economically to keep them employed, keep them at work, keep them doing something, even if you have to make accommodations where they're answering the phone or doing some type of work that is light enough duty where they can meet the accommodations. And so push back, be sure you understand the accommodations, and I strongly recommend you find something for them to do. And every time your employee goes back to the doctor, you've got to be sure that you get the updated restrictions and releases to come back to work, and you need to supply those to Applied Risk Solutions. The last thing I'm going to put up on the screen here is kind of a summary real quick of everything you need to do. Remember, report all injuries. The employee's copy of the medical injury report, the medical authorization form needs to be filled out, sent with the employee to both the drug testing and the treatment facility if they're separate facilities. If you're in a state that has a panel state, be sure that your employee sees one of the doctors on the panel. If this is an employer-directed state, be sure you tell them where to go. Be sure that they get a drug screen. Be sure that you take them to the doctor, that you provide transportation if you can. Be sure you get the releases or the restrictions. Be sure and supply them with light-duty work. Find them something to do and be sure that they know when they're supposed to be at work. Get witness statements. Fill out your supervisor's first report of injury and submit all this to Applied Risk Solutions as quickly as possible so we can help you manage the situation. In summary, these are the things that you have to do so that you minimize your liabilities. You don't want to be accepting responsibility for injuries that are not legally required under the workman's compensation laws. You want to take advantage of the drug-free workplace and not be paying for injuries for people that are impaired. You want to direct the medical care to control those costs. There's a huge difference in the cost of an ER versus an urgent care. There's a big difference in cost if your employees are seeing a legit medical doctor that's treating them versus them going to their attorney's favorite doctor, and the objective is to run up the bills as high as they can to get a quick settlement from the workman's compensation company. These are all critical aspects of managing the claims. Good investigations are priceless. Again, my name's Kirk Livingood. I'm with Applied Risk Solutions. If you ever have any questions, you know how to get a hold of me. Thanks.